Juli Shively here with us. Hey, Julie, how many weeks are we doing this?
5 weeks in a row. This is week number one, and we're excited to keep it going for 5 weeks every Thursday at 3 p.m. Eastern. And we'll have a new guest or guests every week.
That's great. Awesome. Well, we're going to bring on our first guest for the 5-week series, Mr. J.D. Houvener. He's an awesome patent attorney. I'll let him do a little bit of explanation on what he does and what's happening.
Absolutely. Thank you, Carmine, and thank you, Julie, for the invite. It's a pleasure to be here as part of the UIA and the this Youth Innovation Challenge and Championship, I guess, whatever you call it. I mean, it's impressive. I had the opportunity to look at the presentations, the videos that these young innovators have done, and just blown away. I just was smiling the whole time. Just incredible thought, like, oh my gosh, we have some wonderful, we have hope, right? Like there is so much. There's so much coming, and it's just wonderful to see innovation continue. We're getting better all the time. So that is what our firm. We're a law firm. I'm the owner of the firm. Bold Patents, you can see behind me. We have 7 attorneys, patent attorneys. We focus on research, helping inventors, first-time inventors a lot, startups, smaller businesses. Realize what is patent law? Is it the right thing for my business, for my technology? And if it is, then we help them with the application phase, whether it be a provisional, non-provisional design, and then getting them all the way through, fighting with the examiner on their behalf, and then getting it all the way to issuance. And then we support post-grant and helping them with infringement issues as well as validity down the line. But we sort of stop short of litigation and we stay out of the courtroom. And so I have other referral partners that can help take care of that. And when things get messy, we just do the fun stuff and talk about the innovation. So that's it in a nutshell.
That's awesome. JD, do you work with or do you see a lot of young innovators that come into the office and things in that sense?
Well, we are virtual. So, the virtual office, if you will. We don't, as you probably all know or should know, there is no age requirement to be an inventor. Okay. And so we get maybe 10%, let's say, of our clients, of our inventors are under 18. And we bring their parents in to help them sign docs and everything, but they are the named inventor. So it's not a huge amount, but it's wonderful when we get youth. Youth is a general term. I've talked to youthful, 80-year-olds, but when you're talking to younger folks, absolutely, we love to do it. I take a little bit more time, especially because they haven't necessarily been in the business world, and help them understand the big picture with patents. While it is a fun thing and it's a wonderful, accomplishment, the whole purpose of it is to make money. Okay, and to make money, as you know, in the community, it takes not just having a patent. You've got to have a business plan. And there's a whole lot of other things need to happen to bring it to market. And so I sort of, make it our job to make those introductions and those referrals that need to be made to help them think about, how do I want to do this? If patents is part of my process, how am I going to be able to, integrate that to my business plan?
Now, patents, all kinds of intellectual property are super important parts of not only a product, but an overall business plan, like you said. Is there different types? And this is such a huge subject. We could almost do 5 shows alone on intellectual property. But is there certain types of patents? And after you get through that, let's talk a little bit about when someone should really go for or start the process.
Yeah. So there are different types of patents. So there are 3 major types. I think the ones that most people think of, right? Looking at your background behind you, Carmine, you've got the wheels and cogs, right? Things that move and provide functionality. Those are utility patents, right? And so the grant from the patent office says, yep, you get 20 years from the date of filing. You're the only one that's able to make, use, and sell that invention for something functional. The second type is the design patent. Design patents do not protect what something does, but only the way that it looks. I'll just grab the water bottle, pretty easy example, right? And not the fact that it's got this cool spring-loaded top or the aperture at the top, but it's just got this neat aesthetic. Okay, it has a nice cylinder, but it's got a little curved right at the bottom, right? It's somewhat ergonomic, but it's just the design, the proportion, how the lid is structured, the length and the size of it, the design of a article of 3D manufacture, right? It can be built, can be protected with a design patent. So it's a separate type of patent. It's 15 years of protection from the date of grant. Okay, so a little different term. The third type of patent, which is lesser known, and I like talking about it because it's fun. I've been dying to get an inventor that wants us to help them. We have yet to do a plant patent. Okay, plant patents are what you think. It's a plant, the organic stuff that grows out of the dirt. If you're a scientist, a botanist, you can get a patent on something that grows from the ground. If it is a unique variety, and if you can reproduce it in a lab setting, they call it asexual reproduction, where you actually can produce it in a repetitive manner without having to get pollinated, it is patentable, patent eligible. So, I mean, a lot of the bigger companies you think of, Monsanto, those mega corporations that do the GMO work, there's definitely patents behind a lot of that. Around here in Washington, some of the big beer manufacturers, a lot of hops, wine can be, the plants that make up a lot of those beverages are protected under plant patents. So that was kind of the first part of your question. Can you remind me of the second part of the question, Carmine, or what else do you want to talk about?
No, that was great. So the second part of the question, a question that I get all the time, a lot of inventors, they have an idea and they go ask their neighbor. They had the idea. The next day they're talking to their neighbor while they're mowing the lawn, and the neighbor says, "Well, you got to go get a patent." So the question is that I get a lot is, when should I start that process of patenting? Because it's a long process. It could be expensive. So you don't want to not only do you want to, not do out of sequence, but also at the right time. Yeah,
absolutely. I say this to inventors sometimes, and I say it carefully because it sometimes can hurt feelings. Ideas are a dime a dozen. Okay. I know that's probably not what you're expecting me to say. Everybody's got ideas, but do you have an invention? Okay. And so there is a path from an idea to something that's an invention. And I talked about a little bit in my book, Bold Ideas. Okay. And so if you can describe it, or if you've built it so that there's something that is tangible, or you can describe it in such detail so that someone else could go build it and put it to use, now you've got an invention, or you've thought it through enough. You've bounced it around, you've done the work, whether it's through your experience in doing that as a career or studying, right, in an education environment. It takes effort and work, right, to actually have to get to the point to where it's buildable and is real. So that's sort of the first step, is moving from an idea to an invention. And I'm happy to speak with, and I do oftentimes, our team talks with inventors that are still in the idea phase, and we'll help educate them about what the patent process entails, but we're going to say, we're not ready yet. You've got to go back to the drawing board. We highly recommend you keep everything you're working on confidential. Make sure you don't run afoul of any of the statutory bar issues. Don't disclose your invention, even if it is still in that kind of idea phase. If you're going to be working with other parties, try to work with a contract of confidentiality and that type of thing. So that's sort of the first thing is are you ready? And then the second is what you've come up with patent eligible? Okay, there are quite a bit of different subject matter with respect to algorithms or things that are more laws of nature. While they're certainly beneficial and I think a helpful discovery, for example, an equation, like if you've actually developed and uncovered some sort of mathematical equation or a scientific principle, that is wonderful. It's absolutely amazing. Okay, but it likely is not patent eligible. Okay, because it's part of nature. It's not something that's going to be that fits under the patent law. There are other ways that other types of innovations that just don't fit, and you have to be a machine, a process, a method, or it has to be a composition of matter, kind of like a pharmaceutical or a drug, to fit within the patent realm. So understanding, is my invention eligible, is kind of the next step, and it goes from there. I do see a question coming in from Juli as well, saying, what does it mean to disclose your invention? Great question. And so any type of public disclosure is really what the threshold question would be. And so I advise clients to, if they I inform them that there is a 1-year grace period, okay, from when you publicly disclose your invention, which means make it available to someone in the field. So, I mean, obviously sharing it on like a Kickstarter, on a website, in a publication like a journal, even within a school setting. If in a school that's large enough, has a big enough distribution, it's sort of not restrained, not held confidentially within a certain number of people, it could be deemed to be a public disclosure, and that starts a clock. Okay, and you only have 1 year from when that public disclosure was made from when you have to file a patent application. So it's a very strict 1 year statutory bar period. Sometimes I have to break the bad news, right? If someone tells me, oh yeah, we launched this, it kind of flopped, 2.5 years ago, but we want to get it going now. And I have a tough conversation, like, whatever you disclose can unfortunately no longer be filed. But oftentimes we have a positive spin on that, where they maybe have come up with new innovations or improvements of what was disclosed in that time period, and those improvements haven't been disclosed or discussed, and you can seek protection on those improvements. Wow. So, yeah, lots to talk about. Let's see, we have a question from Lexa. I don't know, do you want me to go to the questions, or Carmen, do you have something?
One question on a disclosure. So the question on the disclosure is, I guess we'd say is, if I disclose it, but really no one remembers I disclosed it, should I continue on, or is there a chance that someone that I disclosed it to is starting on the same project? So is there a real disclosure out in the newspaper, or a magazine picks up an article and publishes it? Or if I just tell my neighbor, is that disclosing it, and I kind of blew the whole thing?
Yeah, I mean, it's a tricky deal. I mean, the lens that I have to give advice on is sort of the way in the future. The hypothetical situation is, whatever the invention is, you get the patent granted, all right? It is a wild success, okay? And you're going after the likes of, let's say, Apple for infringing your patent. As soon as you slap them with a suit, okay, and you've got a lot of motivation, you've hired attorneys, you've gotten so excited about this, the first thing Apple and their attorneys will do is try to invalidate your whole patent. Before they even start arguing, we're not infringing, they'll say, no, your patent's not valid. And they're going to find out every single thing that you did before you filed. And so even if it was a little innocent disclosure on a little mini Kickstarter that you launched for a month and then took it down, they will find it. So it's just those are the reasons why you got to be careful. And just by the law, we have to give advice. Was it a public disclosure? Was it findable? Was it ever findable by someone in the art? So you have to kind of weigh your options, and I sometimes give that opinion, and they're like, nah, I'm willing to take the risk, and I'll file anyway. And kudos to them. It's sort of one of those things. There's lots of risks that need to be taken.
Are there some public disclosures that you can be able to publicly disclose, maybe to a few people or whatever, without running into that risk? Oh, no. And so a confidential disclosure does not start that 1 year window. Okay. So a non-public, if you're using an NDA, non-disclosure agreement, a confidentiality document, or if there's a well-reasoned, contract, even if it's verbal, probably arguable that it's safe within a small group of peers or colleagues, or on a encrypted cloud server, right? Those types of things. That's not a public disclosure. It's a confidential disclosure, and so it's not something that would start that 1 year statutory bar. Okay, very cool. Yeah. So Alexa had a question you probably saw come in, and we get this question a lot here at Earmark. U.S. patents, do we go internationally? Obviously, the costs are different, but is there a reason you sometimes advise people to only use U.S.-based patents, or to go international, or are some covered under the U.S. patents? Right. What's nice is there's a wonderful treaty that was signed. It has been signed by 150 plus countries, and almost every country you could ever heard of. First, second, and some third world countries have signed on. And it's called the Patent Cooperation Treaty, the PCT. And you can look it up. The World Intellectual Property Organization has got really good stuff on their website. And I recommend our clients look into that. Okay, it has pretty high administrative costs. Okay, it costs $2,000 to $3,000 just to have it filed. That's the administrative fee that you pay to the patent office. What it does is it buys you more time. So under the traditional timeline, after you file a non-provisional patent application, you get 12 months. And so that's it. So if you don't file the PCT at that 12-month deadline, you have to know which countries you're going to file into and have foreign filings submitted by that 12-month deadline. So most inventors, certainly first-time inventors, that's just not even in their wheelhouse. It's so much to consider to have to hire foreign counsel, to work with intermediaries and get all the translations done and get it submitted.
For most folks, it's better to just buy some more time, test the market out in the US first, or perhaps do some more market research, get some introductions with those maybe potential companies that may already exist in those other foreign jurisdictions, and perhaps negotiate a license, right? You have the potential to get the patents granted in foreign countries. Companies may be willing to pay a license and give you a royalty for each one of the products or services sold in those other countries. So there's lots to think about, with foreign filing. For us, we usually don't, urge one way or the other. What I do is I recommend that they hire or do it themselves some market research. I mean, the key question is there a demand, a sizable enough demand for this invention in that other country? And it's not always true. Sometimes the U.S. market dominates, and that's all that's really going to make sense. It may be just marginal, the diminishing returns to go after other countries. But certainly for a lot of products, it's sort of a worldwide demand, and it makes a lot of sense.
Yeah.
So Jonathan, did that answer your question, or do you want to state your question directly to JD? Because yours might be a little more involved.
I think I still wanted to state mine.
Okay.
So if there's a limited window of opportunity to get your invention to market, say in a couple of years it won't be as prevalent or the demand won't be as high, what's the best route to go? Is it recommended to try and file for a patent? And what if that taking a patent or filing for a patent will take too long and it'll take you out of that window of opportunity?
Okay, good question. I think one thing to consider for that type of technology, if you're pretty certain that it's not going to have a 20-year, market demand, right? You're pretty certain, which I would question you. I would challenge you to on that, right? I bet it's longer than you think. But even if you have a real strong hunch or you've done research that confirms that you think this is going to have a short window of life, I mean, I'm thinking of fidget spinners or little kind of kitschy kind of gadgets, then you would probably not want to do a provisional. You want to file the full formal patent application right away. Okay, and before filing that, of course, I would recommend you do a patentability search, right? Hire a professional to conduct a search, put themselves in the shoes of the patent examiner to give you all the prior art. Prior art is any other reference or patent publication that the examiner might cite to say, nah, this isn't new, or this is an obvious version of something else that already has been out in the public. So go into the application phase, eyes wide open, having done that search, but then not doing the provisional, because what a provisional does is it buys you an additional up to a year of time to kind of go test the market while you're patent pending and that type of thing. But if you know it's a short time span, you got to hit the market quick, and you're likely to see infringers in the marketplace, you want to file that non-provisional, which is the formal application, right away, and likely pay additional fees to expedite. There's a track one. The track one system is a prioritized examination where they guarantee a final determination within 12 months.
Wow.
12 months, which is speedy. And we've been actually having a lot of luck with inventors that are willing to budget that additional cash and get a result within 6 months, right? So, and that's so fast to get a patent in 6 months. And so that's the fastest way to go. That's what I recommend for that type of product.
Yeah, Jonathan, that was a great question. It spurs another question to me. What about seasonal type products that we know are only going to be on the shelf for one season, and by the time the next season comes around, they probably will have changed over? Is it smart to do that, or should you do more of a design patent, or maybe just do provisionals? What do you think about those?
Well, I mean, yeah, that's something you have to kind of weigh. I mean, if you certainly have to do an ROI on the mega level ROI is spending 10, 20 grand, getting a patent granted, going to be worth it? Are you going to get a payback on that? So if it's one season, you're pretty sure it's going to be just a up and gone kind of a product. Patents may not be your jam for that product. Just get it out in the marketplace, sell it like hotcakes, and move on to the next one. But also, all right, don't forget about making sure you're not going to tread on someone else's patent. Okay, so if you're just out there selling, which is what we work with a lot of clients. After we do our search, we say, you know what, we don't think you should file. And they're like, all right, well, I'm still going to go sell it. I'm like, well, hold on. Let's do a quick peek to see if there's anyone else that has enforceable rights that may be coming after you if this becomes wildly successful. So you have to kind of look and do what we call freedom to operate opinion are you free to operate without risk of suit from another patent holder?
That's what I like about talking with JD. He's got like a crystal ball. He knows what's going to work, what isn't. So I go to him with a product and he says, yeah, this is going to be fine. Just you must get a lot of inventors that come to you. And I know we work together too. And, are people sometimes just asking you your opinion on products? And in reality, kind of like on my end, you're just looking at how to make their product safe to put out on the market, right? It's hard to give your opinion sometimes on it.
Yeah. At the end of the consult, people are always like, JD, so all that was great, but like, what do you think? And that's always hard. And I always just say, look, from my own experience, I buy products like that. I like it. I mean, whatever. I mean, I try to give my honest feedback, but it's hard to separate that. We are attorneys. I'm an attorney, so I need to give legal advice, which inherently is, boring, or it's just sort of straight. It's not marketing. It's not sales and marketing, which is the answer that they really need. And maybe one of the anecdotal or sort of the answer is ask the question of the right person, right? A patent attorney is not going to be able to tell you, for example, about other clients' inventions, and so maybe that's, and also if you're asking about, is my product going to be successful in the market, that is actually not a good question to ask a patent attorney. It's not, the question is, can I get a patent on this? That's a great question. How different does my product need to be to get a patent is a good question, but how viable will it be? How much success will I have? I mean, honestly, what I've seen in my, relatively short time of doing this, it's if you hustle hard enough, if you want it, if you care enough, you will be successful. It's sort of really cliche, but it's like, if you are willing to work hard at anything, you will be successful, with or without patents, but patents can help.
Yeah.
Well,
I like what you said about a patent. Yeah. It's more for being down the road, that when you are successful, you get to. So if you put, you put 10 years into this product and you're successful, if you haven't done the right intellectual property, you haven't laid the right foundation, that's kind of what you're talking about, is like, protecting yourself for when you are successful.
Totally. Yeah. And we're a young law firm. We've only been out there for 7 or 8 years. And it may seem like a long time, but it's not. Like, we haven't been, for example, hopefully we're going to get a lot of clients that over the years will be wildly successful, right? But it's when those patents get litigated, right? And there's judges looking at the claims that our firm wrote. That's where we either shine or we don't shine. So, anyway, I kind of lost a little bit of track, but it's, and it's also about, you have to plan for success, right? Hope is the best, plan for the worst. Is that right? Yeah. Prepare for the, hope is best, prepare for the worst. But it's like, you have to put everything in line, do the diligence, do the right things, so that you can, when you are successful, you won't have any regrets.
Yeah. We plan for 30 minutes on the show, but if we go a little over, because this is such an important subject, Lexa kind of had a question that I was thinking about too. Here at Earmark, we get a lot of inventions that I call Reese's peanut butter cups, meaning they're taking peanut butter and they put chocolate, they put it together. They didn't really invent anything, but they're taking products that are already out in the market and putting them together, and now they're doing something different. So that's kind of what Lexa's asking in her question. Is something like that patentable, or how do you go around? How do you start that process?
Yeah. It really is. It's the same inquiry. The difficulty is going to be, is it obvious to combine those two elements or three elements, whatever it is. And so that's what a patentability search will do. It will pull all the prior art from, professionals, in the industry, confectionists, all the different recipes. Food related inventions are extremely challenging. People have been cooking for so long and publishing. it's almost impossible, right, to get a recipe patented. There are ways to get compositions of elements. Typically, it's more than two, but and also, even if the actual end composition, right, chocolate and peanut butter, if that's not new, I don't think it is. But if you've got a method of cooking that, or making it, and there's maybe 8 or so steps to it with the heating and cooling, and maybe it's got pockets of air in there, or perhaps it's the specific type and viscosity of peanut butter with a percentage of peanuts, or types or mixture, right? There's lots of sub layers. I bet there are folks that deal in that,
You're
minutia.
getting everybody hungry over.
Yeah, right. It's almost lunch over here. It's 12:30 over here. But yeah, so there's always ways to think about, diving into details and helping someone think through. But then at the end of the day, it's a question of, if you own bubbly 30 to 35% viscous peanut butter combined with only a 90% type of cocoa chocolate, and that's all you own, is there enough demand? Is there enough market potential to go after just having a patent on that very specific thing? Likely not. But that's up for the inventor to decide. Is it worth spending what could be more than 10 grand getting the patent on that extremely specific scope?
Cool. Hey, Travis, you have a question? You want to unmute?
Sure, thank you. Thank you for taking the time today. And I had a question that was specific to me, but I feel like it could apply to a lot more people. I'm 15 and I'm looking to get a full non-provisional patent, but since I'm only 15, I don't really have a source of income. I was wondering, what would you recommend somebody in my shoes doing in that case?
All right. Well, when I was 15, I worked at Taco Bell. No, I'm just kidding. I don't think you should go. I think you should stay. I saw, what you put together with that basketball assistant thing. That's awesome, by the way. So with no money, typically you are rich in time. Okay, you've got time, my friend. And so if you have time, you have money. In other words, where you have the ability to make progress and do some research on your own. And so I've got you. I think you all got a copy of this book via PDF version. If you didn't, I can get that to you. In the very back, I kind of hide it in the back, chapter 26. I give you some free resources, and they're kind of obvious ones, but let me start with Google. Okay, Google Patents got a specific Google patent search. There's the advanced Google patent search, free patents online. USPTO.gov has some awesome resources, and then there's international resources. But basically what I'm saying is, before you think about filing or writing a patent application, do conduct more diligence and research. And I was happy to see in your video that you found that other competitor that had that flick grip or whatever it was. I mean, that's nice. You're doing some research. I like it. But I would say stay at it. If you haven't done, 20 or so hours worth of research, I would kind of send you back and have you do some more. And then after you're doing that research and you're convinced yourself that it really is new and it's not an obvious version of another type of device like what you've come up with, I think then it's ready for filing. And I would say then, in all honesty, I think you should still try to hire a professional. And if you don't have any money, then my first recommendation is to speak with family and friends to see if they can help you take that step. Consider interview a patent attorney to help you with that. Of course, being a little biased, I encourage you to speak with a patent attorney, because they're going to help you think about what it might happen if it does go to litigation, right? But certainly patent agents can help you as well and are more affordable. But yeah, I would try to get some help with financing that, but do not write the patent application on your own. I don't recommend you doing that.
How do you reconcile you have lots of time because you're only 15, but you only have a certain amount of time to file a patent, right?
Yeah.
Did I miss something in there?
What I was saying is, if he doesn't have a lot of money, but he has time. And so what I mean by that is he has the ability to go do that research and do a lot of heavy lifting on his own to make sure he's done as much of the drafting, the writing, perhaps even some of the drawings on his own in advance. But in terms of the timelines for when you have to file, if you've already publicly disclosed your invention, you bet you're on a timeline. So you've got to file it within that window. I'm I'm hoping you have more than a couple days, Travis. But I mean, even if it's a few months away, you're in good shape, right? So usually you want to allow a couple, 3 months or so for an attorney to be able to prepare a really solid non-provisional patent application for you.
Awesome. Hey, Jonathan, you have another question?
Yes, sir. So when approaching like a large company, if say I had something that they may be interested in and I wanted to try and pursue a possible licensing deal, is getting a patent beforehand necessary?
Yes. I mean, the licensing is the concept where you're actually, what is being licensed is the intellectual property. And so it is either a pending patent application or it's a granted patent application, or oftentimes a portfolio. There's several patent, trademark even, or other types of IP that get negotiated in that contract. And I have heard of deals that get done while patents are pending. And I have some pretty good resources for you and for our inventors for talking with companies that all they do is help inventors get licensing deals. That's their sole focus. Our focus at the firm here is to help you get the best patent possible. We have sort of stayed away from going out beyond that in terms of helping you, monetize and get a licensing deal. So those are the folks that I like to refer to. One is Invent Right. I like Andrew Krause at Invent Right. There's a few others, but he's got a coaching program where they'll help you kind of think through what type of pitch deck do you need, how do you approach, or would you want to do that on your own or have a representative, right? Kind of think through what are the different scenarios there. And if you've got an idea of a company or maybe 2 or 3 that you like and you could foresee that maybe they're already in the same industry. I mean, for you, it's that exhausting, right? Maybe you've already got companies that are out there doing they're already in catalytic converters, or maybe they're already into emissions, performance type stuff, then that's even better. If you've identified potential licensees, that's going to help you a lot. And that's that market research you can do on your own before the meeting starts.
Can I follow up that with a question too? So if Jonathan were to patent you in the US and then license it, and I know you talked about earlier, sometimes those licensors might consider helping with patents. Is there a clock though for those international patents like there is for the US? Or is that depend on the different country that you want to find a patent in or file for patent in?
Well, the answer I think requires a flow chart. Julie, can I share my screen?
Of course.
Okay, very good.
Sorry for asking that.
So much. No, it's
it's
really good. It's really good. I need a crib sheet. I need some help. So my PCT guide, I can send this out to you guys. Okay, here we go. Page 2.
Is that in your book?
I have a new version coming out.
Okay.
I got version 2. I'll get you a copy of that. So does your invention have a market overseas, right? I asked that question first. So first ask this question. If you think so, or or even if you're not sure, it's usually yes. So the PCT, I mentioned it earlier, that's this treaty I talked about, and 150 countries plus have signed on. There's links to that on the WIPO website. So your US-based patent attorney will help you file. And as soon as and you'll see in the flow chart how this works. Can you guys see that? Do I need to zoom in a little bit more?
My old eyes can see it, so I bet theirs can.
You can? Okay. So here is the priority date, okay, in the US. Actually, I'll use my next page. I've got some circles. This is smaller. Hopefully you guys can see that. Okay. So I've got it in dotted gray line. Don't forget to do a patentability search and opinion. I know Carmen's probably sick of me saying that, but that is huge. And so, a lot of you guys are, like I said, can't necessarily afford it, but do it on your own. Do as much diligence as you can to confirm what you've got is new and non-obvious. So before you file, do the search. Day 0 is your filing date. So whether you do a provisional, which is a less formal, basically a placeholder in the US, a design patent, or the non-provisional, the provisional or design, is the 0 priority date, okay? and in the US. Then you've got to file the PCT within 12 months of that priority date. Okay, so if you did a non-provisional here at 0, you'd have 12 months to file the PCT. But most first-time inventors, they file a provisional because they just want to make sure, they want to kind of, tiptoe in, dip their toe in the water, test it out, and they want to kind of get some manufacturing, test out the market, get some customer feedback and that type of thing. So at the 12-month mark, that's when the PCT gets filed. And there's a lot of stuff that happens that I'm going to kind of skip over. But the important part to remember is that all these countries that are signed onto this treaty, and there's 150, they will all recognize this priority date. I think that's what you're asking about, Julie. So there's no need to worry about dates. Once you filed in the US, that is the date for the worldwide priority. And what the PCT does, I was explaining earlier, is it allows you this additional time all the way to month 30. So 18 months after that 12-month date to then file in the foreign countries. So it gives you time to maybe save up money, have conversations, maybe even get into a licensing deal in this time period. The other beauty is that the other countries will all recognize the search, the one search that was done by the US examiner. So the other foreign countries don't need to do their own searches. They'll all honor and respect that one search that was done by the US patent examiner. So you guys follow that? Make sense?
Did you say that you would send that to me, and am I allowed to send it to these students?
Yeah, of course.
Okay, great.
I might throw a copyright bold on there, but yeah, I'll send it over to you.
Okay,
Okay. Send PCT flow
that's
chart.
wonderful. Thank you.
Of course.
So
JD, while
I
you're
just
doing that,
have
a
another
couple more
question.
questions.
I'm always confused
Go ahead, Jim.
about what happens after your time is up and you don't have your patent filed yet. Does that mean you can never personally file a patent for it unless you make significant changes to it? Or does that mean nobody can file a patent to it?
Yeah, if it was publicly disclosed before filing, only you have the ability to file within 1 year. Okay, you're the inventor. But if more than 1 year goes by, it is part of the public domain. Thank you so much for sharing your wonderful invention.
Do you still
And
have
so-
the ability to try to patent it though? Just not
Nope.
exclusively?
No one can. Yeah, no one can after
Oh.
it's been publicly disclosed. And a lot of companies do that. IBM is really notorious for doing defensive publications where they sneakily think about what their competitors are up to. And they just send out huge, wonderful, long journals talking about these wonderful ideas. And all of a sudden it's part of the public domain and no one else can get a patent on it. So it is, it's great knowledge, but it's strategic as well. And so it can be a way to, a lot of people that are out there that don't like the patent system for a lot of, different reasons, and they just want to go share and free source it. That's all part of the public domain too. And examiners find that stuff all the time. And even if they don't, even if examiners don't find a piece of prior art, if and when that patent holder goes to try to leverage it in court, you bet their attorneys will find it and say, oh, the examiner missed this patent is invalid. So there's a lot of different things that can happen in terms of publication that are not always good.
Okay.
Wow. Hey, JD, we're going to get about 5 minutes left. Quick question.
Yep.
I hear all the time big companies fighting each other. How hard is it, and what does it entail to, I guess I wouldn't use the right terminology, patent an app for the phone?
I may have missed a little bit of that. So two big companies fighting each other, and then what was about the app?
Oh, no. I just hear a lot about electronics, patenting code. And also
Okay.
I get a lot of questions here at Earmark about an app or an application for a phone.
Yep.
How do they go about patenting it? And it seems to me that's pretty tough to do.
Yeah. Well, so first thing to understand is that it is not the actual software code that is protected under patent law. The coding itself, that is just one way of telling a computer how to execute certain functions. That's like telling a story, right? A story can be written a million different ways. That's actually the domain of copyright, okay, for the way that something is written under code. But more importantly, the question is what the software does, is the functionality, what it performs, steps, the operations, the inputs and outputs, how it stores, how it validates, what it actually provides for the users. Is that unique? And is it a non-obvious version from any other type of functionality that's been published before, using a computer implemented invention. I know it's a mouthful, but that's really the threshold question of is my software, is this method of this process that I'm happening to use a computer and a computer network to perform that method or process through unique and non-obvious. And if it is, it's patent eligible all day long. And those get issued from all sorts of companies.
Wow. Have you done any patents on apps?
We have, yeah, we've done quite a few. Actually, one of the most, it's not quite made a big, huge move yet, but a company that's doing lock boxes for rental properties, kind of for Airbnbs. It's called the Lubin box, Lubn. And so they've got the hardware component for it, but there's also software behind how it actually is able to encrypt and securely unlock for tenants remotely. So the owners of the home don't need to be there. Kind of one of those, use your smartphone to sort of tap or come into proximity with it. There's a few things that happen behind the scenes with the software to allow that exchange to happen. And that's been in the market now for a few years, and they've had a lot of success in the US and overseas.
That's pretty cool. I thought you were just going to say that you did that Fortnite app.
No, man, that would have to be sweet. I've heard of that, yeah.
I have one more question if JD will allow me to ask any more questions, because I've asked so many.
Yep, no, you're good.
Is there any value to just an idea? Can somebody take an idea somewhere and say, I just want you to buy this. I'll give you this idea. Give me this much, a few $1,000s, $100,000, whatever. I have an idea that will, that will make, you can go ahead and go try to patent it and do all this other stuff to it.
Hang on, let me get my pen because I want the name of the place.
Well, okay.
I mean, it's a no, but it should be a yes. It should be a yes.
There were a few things there. I mean, for the first question, an idea is worth whatever someone's willing to pay for it, right? Or however you can sell it for. That's the kind of the dumb, easy answer. But the other thing is, I think you mentioned at the very end, if I tell someone about my idea, which may be an invention, and they then go try to get a patent on it, they're defrauding the patent office. They're not the inventor. You have to be the inventor to file for a patent application. Yeah. So in that case, what that second party, that third party would do is they would have to say, hey, I need you to be named as the inventor, sign this document. I'm going to need you to assign the ownership to me. And that way they can legally become the owner, the assignee of the patent. But they are not the inventor. The inventor must be named. It's a super important part of the patent system.
Okay.
So that opens up.
Yeah, but I mean, like I said earlier,
I have all these ideas, JD. I just don't want to go through all that work. I'm telling you.
Well, you're not alone, but I think if you've got one that means enough to you, I think you'll make that move, all right? You will. And so when you do, we'll be here to help.
So
thanks so much for your time today. It was great.
You bet.
All right, JD, let's just put out there for anybody else that's listening on YouTube and for our people here, how to get in touch with you.
Yeah, well, we have Bold Patents. You can go look us up online. boldip.com is still our domain. We do handle trademarks as well, so it's kind of under that umbrella. I'm on Facebook. I have a Facebook, YouTube, LinkedIn Live that I do every Wednesday, and I'm trying to get more people there. It's fun to get live questions like this. I mean, it's awesome. So yeah, go to our Bold Patents Facebook page, interact with us there. I've got a lot of blog articles on our website. And if you're ready to move forward, there is a free screening session, we call it. And that is sort of the ability for our team to screen you, listen to what you've come up with, see if you're at that invention stage yet. And if you are, then they can get you lined up to speak with one of our patent attorneys to do a legal consultation to talk about eligibility.
Very cool. No more questions?
Carmine, can I just thank Jonathan, Travis, Paisley, and Casely, all who are top 10 innovators at the National Innovator Challenge, for coming to our session today. We look forward to seeing you at the next session, as well as some of your contemporaries that were also in the program.
Yeah, so awesome. This innovation series is going to be great. We got some great speakers. JD led it off. Awesome information, JD. I thank you so much for coming on. I mean, this is it, man. This is the foundation, what you do. It's so important.
You're welcome. You're welcome. Yeah, it's a great opportunity to be here. And I'll extend the offer to any of the innovators, the top 10 here. If you want to reach out to me, I'll happily follow up solo. And I'll put my email address in here. You can just email me directly if you have some questions. I want to reward you for taking all that action that you have been doing. So be happy to speak with you.
Very cool. All right. Well, we're going to close up the show. Number 1 of 5. Any of you guys out there listening in, please tune in next Thursday at 3 p.m. Eastern Time. Go on out to our UIA TV YouTube channel. You can watch live and get in touch with us if you have any questions. We'd love to throw questions out to our guest speakers. And we will catch you next time on UIA TV.